Mr. Hellman is absent. Elizabeth Dixon. Bart Howard.
Present.
Elizabeth Trinkler.
Present.
Steve Harb.
Present.
We have a quorum, sir.
Thank you, ma'am. And would you read the notice of meeting for us, please?
Notice of the September 9th, 2015 meeting of the Collection Service Board meeting was posted to the Collection Board website on August 20th, 2015.
Minutes, has everyone had an opportunity to read the minutes from email? Are there
Yes.
any corrections or additions to the minutes? If not,
Second.
all in favor?
Aye.
Aye.
Okay, motion passes. Y'all reviewed the agenda for today's meeting? Not in my order. Questions about the agenda? All in
Motion to adopt it, or?
Motion's been made. Is there a second?
Second.
Second, all in favor of approving the agenda, say aye.
Aye.
Aye. Director's report, legislative update. Which is it?
Starts on page 12 on your iPads, though, if you're just turning.
Nice.
That's a Dennis O'Brien trick.
Magic.
Okay, thank you.
Right.
Correct.
Okay. At the top of the director's report for you, as always, is our budget information for the last 4 years, as well as the current update for the expenditures and revenue. This is as of June 30th, 2015. The total expenditures were $109,192.63. The total revenue was $338,056.78. This is not budget close has not happened yet. So these numbers I expect to be slightly updated, but this should be pretty close to final.
We're going to have a 200,000 margin this year?
I think so, yes. And we do intend to present, so we are actually anticipating being in the black by a good margin this year. Our license counts for collection service manager is 806. That number should drop off as that profession code is no longer an active code. The collection service agencies is 867. We have 243 voluntary surrendered and 1 revoked license.
Voluntary surrendered?
Yeah.
Okay. And in this year, we had 243 voluntarily surrendered?
Yeah.
I'll seen that number last year.
It's a little high, but it's not, it's generally a little less than 200 or around 200, so it's a little bit high.
Law didn't really change that much, the change in the
Election manager law changed too, so that had some effect.
The voluntary surrender is off of the collection service agencies. I didn't do it off the collection service man. To run it off of that number. I did a capture of our complaint numbers so that you have a percentage. We are well into the 90th percentile, so we have 93.52% on time for complaint performance measures, which is very, very good. Thank you. And I also showed July's renewals and our initial applications processed. Below that, 43 licenses expiring in July. We've already renewed 14 of them. 28 had not renewed yet, and 2 of them had been denied. 15 initial applications received, and we'd already approved. There were no legislative updates this month. Keeling and I are headed to the NACARA conference this meeting, September 28th through 30th.
Where is that meeting?
It's in Colorado, in Denver.
Oh.
Cold, Keelan.
I know I'm gonna have to pack like 12 sweaters. Some boots.
Good news is, once you
And
get into the
skis.
hotel,
Yes,
we won't need to go
I was
outside.
trying not to tell you.
You're in trouble.
We presented this last month, but Attorney Brian Ellis has requested to be present at this meeting. His questions at the last board month were answered by the board, but apparently the audio for the meeting was not well picked up, and he couldn't hear the answers the board gave to the questions. So he's come to this meeting, and he'd like to ask the questions again and just get the direct feedback. He flew all the way here to get the answers. So if this, at this time, if it's okay with the board members, I'd like to turn this over and let Mr. Ellis ask his questions directly to the board members.
Certainly.
Do we have last month's answers? Last time's answers?
Well, I included in the board documents the question, the letter that he sent all of you, and you answered it on the record as part of the minutes. If you want to look in the minutes, a summary of your answers should be in there.
Okay, first off, good morning. Thank you to Chairman Howard and the board for letting me visit today. You know, over the past few months, I've had occasion to send this similar letter, identical letter actually, to a number of other jurisdictions. Basically, what my client is seeking is some sort of efficient way of licensing themselves across the country with locations throughout the world. And so the reason my letter is to, you know, see if we can't figure out a way to you know, have their compliance. Those are the genesis of my questions. The first one being, you know, whether or not a licensee could conduct collection service business at the location of an affiliate, assuming that we notified you of that location or registered that location as a branch or something. I think some of what I heard on the video previously online kind of dealt with the fact of, you know, whether or not the monies were ever coming back, you know, to the licensee from the affiliate, et cetera. However, you'll note in my letter that my client doesn't receive, handle, or touch any consumer monies. When they call to, you know, collect debt, if you will, they're just doing so on behalf of their client, in the name of the client, instructing them, the consumer, to make a payment directly to the client. Not paid a percentage of those monies. They're paid on a flat fee like a call center. In fact, this particular part of their business is a small part of what they do. The bigger part of what they do, they're consultants, and they do accounts receivables management for large. So they're doing accounting for them, basically, but some of that entails call center employees making these phone calls, et cetera, on behalf of their client. Our conservative reading of your statute would appear to require them to be licensed, but what we're trying to do is avoid having a location in India, the Philippines, Czechoslovakia, Argentina, et cetera, all separately licensed with your office, when we have one basically standard-bearing entity that would be the lead, that would be licensed with your office, and under the auspices of that entity, the licenses would be contained. And that's basically the first question.
You indicated that you call in the name of your client. And is this bad debt or good debt? Has this been charged off, or is this just a routine collection, follow-up call on an outstanding item?
Yeah, you know, what my client does in order to avoid having to comply with the Fair Debt Collection Practices Act is they meet with their client and they contractually define default. When they determine what default is, it's excluded from the work that my client does.
You're calling in the name of the client on the client's business.
Exactly, for things that may be late, but are not in default and are certainly not charged off.
They don't identify themselves as anyone but the client.
Correct.
Our laws don't cover you. Is that correct, Bart?
I don't think they do, as long as you're not collecting in the name of a third-party name,
Okay.
then
The only thing that, like I said, that we wanted to make clear, and I wasn't necessarily coming here for an exemption, but if I can get one, I'll take it. And to be clear, we are a third party. We don't buy this debt. It's not assigned to us. None of that happens. These are all our clients' accounts. We just do all the work correct.
Not
in
a
the name of the
third
client.
party unless you use your name.
Okay. Well,
You
let
are an
me-
extension by contract
office,
of
we
the,
call
of
it,
the,
or-
of the company.
Well, I appreciate your view of that. I have had East Coast regulators tell me that you're a third party, even if you're working in a first party capacity. And I'm like, we're not trying to upset. Exactly. I get into a situation where, you know, your guys are leading me down a primrose path if you view me as a pure third party, because my client's engaged to do this work in a first party capacity so that we don't alarm a consumer or a debtor. They're certainly not expecting to get some sort of threatening letter or communication from someone indicates third party when it may be 2 or 3 days late, and we're just reminding them that a payment is due. So I appreciate your, you know, understanding the nuances of this and potentially putting us in a position where we may be able to get an exemption.
All in Tennessee, then I don't believe you're under our laws. Because
when you make a call to the consumer, he gets a caller ID, and if that consumer returns that call, how is the phone answered?
I believe all of that is shown as the client's name. There is no way that I believe that my client's name shows up on anything. There is complete invisibility.
your client, okay.
Yeah, my client,
Right.
the actual,
The original
the
creditor
licensee,
is what
exactly.
shows up.
The creditor's name would show up, or maybe just a 1-800 number or something like that, but nothing, no indicia of my client being involved shows up anywhere.
The operator answers the call. How do they answer the call? Just hello, or do they say the name of the client? This is XYZ.
I think technologically they're able to answer it in the name of the client. The consumer should in no way know that they're receiving a call from my client. It looks as if, you know, their creditor, if you will, is the one that's making the call. In fact, that's what they want. These creditor clients don't want to have their own in-house call center. That's what they engage my client for, and to do this accounting and other stuff for them. And so that's why they engage them. So that's what they're offering them. And if it came to the point of someone not paying, and it became in default or something like that, then those accounts would be transferred to somebody that is licensed as a third-party debt collector, and they would collect, but my client does not do that.
Point of clarity, this is not an exemption.
Okay.
You don't fall under our law.
So we don't
So
even...
we're not
okay.
exempting you from something because you're not
Okay,
subject to it.
perfect.
Would that be a correct way
Yeah,
of saying it?
I think that's correct. We don't have the authority to exempt you. But in clarity, I don't think as long as the consumer doesn't recognize someone is collecting an account from him other than the original creditor.
Right.
So if it's whatever it might be, it's got to be collected in the name of that original creditor.
That's absolutely the way it is. One other quick point that I want to make clear, approximately 1% of what they do is consumer, so personal, family, household. 99% of it's commercial, so it's business debt. So just so you're aware of that as well, I think that helps a little bit also. We're very conservative. We want to comply with the law. That's what my clients want to do.
When you're collecting consumer or commercial debt, you still have to have a license if you are
Correct.
if you are a collection. But I don't think that you have a reason to even apply for a license.
So we can finish this up and you guys can get on with your business. Would it be possible for me to receive a letter or to send you a letter and get something back that just clarifies the position so I can present it to my client? We can put it in the file. And all it would say is, you know, the current laws as they stand in Tennessee do not apply to these activities, and therefore you don't need seek a license as a collection agency or a collection
That'd
service
be-
board.
Would that be proper?
I can draft a letter.
Okay.
And then have you sign off on it, and then we can send it.
Like I said, I thank you for the opportunity to come here and clarify. I wanted to make sure that we were on the same page, and I appreciate this chance.
Where'd you fly from?
Not too far.
You have
Thanks
to
for
go
bringing,
back?
thanks for bringing some money to Middle Tennessee.
Well, absolutely. This is the first time I've been in front of a microphone down here and haven't had somebody singing into it. So everybody's very talented.
And you're real lucky we're not.
Thank you, Ms. Ellis.
Thank you so
Thank
much.
you.
Thank you.
That concludes the director's report updates.
Legal report? Did everyone have an opportunity to read the legal report, or do you want me to? I got it on my email yesterday or day before yesterday. I've read through it. Steve, have you had a chance to read through it?
But is it required to be read in anyway?
No, sir.
not?
But I'm just going to give you an opportunity to read the specific issues, and you just tell me when you're.
I read it quickly. I'll read it again. Reading on my phone is not easiest.
Oh, really?
Just let me know when you're ready. Just take your time.
I'm sorry. I'll stay over here in Siberia. I apologize. I know it's disruptive. No, I mean, I only got back yesterday at 5 o'clock, so I'm just plunking right ahead.
I think we're ready to go. Any questions about any of these from the board?
I was just wondering if, in the investigation, this agency, how many letters or contacts they had made within.
Um, yeah, I think that in this particular, you're talking about number 11, correct? In this particular matter, we only have the record of the one. I don't think we have record of multiple letters in this one. We can, if you would like to do it this way, we can go ahead and deal with this one, correct? And then open up another complaint to investigate specifically that at the request of the commission, if you guys would like to do that, just to make sure it's not happening over and over and over.
I think it would be real easy to find out. I think you could ask for records. I mean, there's no reason to think that they only called on this one if they had a whole book of business for Tennessee. Perhaps the client or the respondent, either one, could tell you how many accounts, how many calls, and
Okay. Okay.
Could you tell from the complaint whether it was a client based in Tennessee?
The respondent is not located within the state, so we would. Oh, the client itself. Yeah, the complainant would have had to have been in Tennessee for us to have jurisdiction over this. So yeah.
Another violation for soliciting.
Right. Right.
Solicit that business, then that would be a violation.
I think this was a consumer complaint, so it wasn't the client that complained. I don't know. I guess I can't recall.
Bank of America, that's
Right,
one thing.
right.
If it's Jane's Dress Shop, then it's another thing.
Yeah, we can look into that too.
that would be another board, I guess, maybe issue that we could open up.
Else on 11? I have a question about number 12.
Okay.
It says in here in the last second to the last sentence of the respondent. 3 electronic checks in the amount of $200 each that were paid to the collection service.
Right.
I don't see that those were credited to the account.
I think what happened in this situation is the payments that the consumer were making, the $200 payments. From what I can see, they thought they were making them to the respondent in this matter, but they were actually making them to a separate collection agency. So those wouldn't have been credited to payment to the respondent. There was some confusion with this complainant as to where those $200 checks were going. They were under the impression they were paying them to the respondent when in fact it was a totally separate
Other
collection agency. I found that a lot of times in the complainants, sometimes there's confusion because they think they're paying one person and they're actually paying somebody else who in their mind, I think, seems like it should be affiliated with that person because sometimes the names are very similar. I mean, sometimes it'll be a hospital and then a separate medical group with just doctors, and they're under the impression that they're paying one person when in all actuality they're not. So, and that's what happened here.
And it's in your recommendation is that the agency was attempting to collect a debt that wasn't legal.
Right.
I know about the $9, but it seems to me, and Elizabeth, fee, and it's $30, and it's posted like it's supposed to be posted for.
Right.
It's the UCC rules. I'm not sure, but if it's posted, then the collection agency can indeed attempt to collect
Okay.
that $30 fee.
If it was a charge from the bank, or what if the
Now-
agency was actually charged that?
Oh, okay.
And it could be that you guys might have said that some time ago and I wasn't aware of it, but I understand what you're saying. Yeah.
But this is an electronic transaction. Notice is made to the consumer that if he gives them
Yeah, I don't know. In my mind, I don't know that there's a big distinction there based on what you're saying. I didn't know that you guys had approved that in the past, but
well, we don't know. We're not.
right, I don't know if
Yeah.
an electronic check fee, I don't know if there would be a huge distinction there. We might want to think about, based on what you're saying, we might want to think about changing that recommendation to a letter of warning just to kind of lay it out for them so that they understand rather than the civil penalty. Because if what you're saying you guys kind of thought about in the past, then it might be better to go that route.
I think a letter of warning is fine if the rest of the board agrees. But I think for our sake, we need to know, and for the agency's sake, authorize a return check fee for an insufficient electronic funds
Right.
transfer.
Let me see what this says. I don't even know if it makes the distinction in the statute.
Doesn't in our statute. There's another statute that, it used to be years ago, it was a $20 fee. Remember, Elizabeth? And then
Yeah.
there was a big lawsuit. $30, and then it added a $9 check fee to.
I can check on that and report back to the board next time.
Yeah, let's do,
I don't know what we would even be able to do about that, since our statute just refers to insufficient fund checks and not. Yeah, even if it's an electronic check, it's still an insufficient fund. So there's really, I mean, I guess in my mind, there's not really a distinction. Like, but I think if what you're saying, you guys kind of talked about in the past is the way we're going to go in this situation, it might be better to do a letter of warning and then
Now, let's do.
for future complaints.
Okay. Yeah,
Because I want to know too. I need to be on the right page too. So
I'd rather see a letter of warning than a fine.
okay.
To
Yeah, we have any new business?
accept the
Oh, yes, I'm sorry.
legal report?
Yes.
So moved.
There's been a motion made to accept the legal report with the changes we discussed. Is there a second? Favor? Aye.
I think before we get to the new business, that I should probably read just at least the complaint numbers into the report and get those on the record. I don't need to read anything else except the numbers.
Okay.
So item 1 is 2015007141. Item 2, 2015007461. Item 3, 2015007271. Item 4, 2014018131. Item 5, 2015007101. Item 6, 2015011081. Item 7, 2015011881. Item 8, 2015012211. Item 9, 2015013681. Item 10, 2015015071. Item 11, 2015015391. Item 12, 2015015581. Item 13, 2015016261. And item 14, 2015017281. Thank you.
New business?
I just wanted to let the board know that as of 9:00. Regulatory boards and all of commerce and insurance, we have a new licensing system.
Does a collection service license expire every year, or is it every 2 years? So back on the financial report, the big money was this year. Next year, we won't have that much money. Is that right?
Yeah, it's lumpy.
No more new business?
No, sir.
Entertain motion, we adjourn.